super glad to introduce, and Kurt, our rule of engagement here is that we do very short introductions.
That's great. Is that it?
I should shut up, but I won't. But Kurt Bradley really is a legend here at Duke Law School, and he's a legend nationally for his writings on constitutional law, and he has very much of a national security view or study of constitutional law. And I'm really glad to have him here because he does have a new book and he has some really interesting ideas and have been very formative in the way I teach national security law. So, Kurt, the floor is yours.
Thanks, Charlie. Thanks, everybody. It's always a pleasure to be back here at Duke. As Charlie said, I have long and deep connections here. I taught on the faculty here for 16 years, and only a few years ago went to a much colder climate in Chicago. It's also a great pleasure to participate in the 30th anniversary of this major national security conference. I am going to talk about my book just for Charlie and for this conference. I have been giving this talk a lot, but I completely changed it, so it'll be somewhat fresh for me and hopefully for you, because I've made the second half of it very focused on national security, which is, I don't always do that because the book covers a lot of different topics, but I thought for this conference that would be a good idea. So this is the book. Just came out late fall. You can see there's sort of a militaristic angle and a nationalistic one on the cover. We'll get to that. So I thought I'd say a few things just generally about what I tried to do in the book, and then I'm going to take one case study that's just one chapter in the book, but it's about the use of military force. So people in this room, many of you would know a lot about this topic. The core question in the book, quite simple, is when we're thinking about the power to deal with foreign affairs of all sorts, who gets it? How do we distribute it between Congress, the legislative branch, and the executive? And now, if you were a student thinking about this, the first thing you ought to think about, I would think about, is what's the text of the Constitution tell us about this? And what you would find, and I always get surprised even now to find this fact, it tells you surprisingly little about the distribution. It actually doesn't even mention a large number of foreign affairs powers that we would all take for granted. They're not anywhere in the text, let alone any text about how they're distributed. I could go on about this, I won't. No mention the power to declare neutrality. Turned out to be a big issue a few years after the Constitution took effect with respect to France. No recognition power. How do we decide whether to recognize any state or territories? Nothing in the constitutional text. How about issuing passports? Well, we didn't do much in the early days, but there's no text. But of course, it's a big issue today. Extradition, sending criminal suspects abroad. Where's that in the Constitution? You won't find it. What about a big topic today and every day? Immigration. It's always in the news. Where's the immigration clause in the Constitution? There isn't one. There's one clause about naturalization, nothing else. And we could keep going on the war stuff, which I'll get to. There is stuff about war. It's actually one of the heavily covered topics in the text. But nothing about what to do about undeclared wars, which turn out to be the most common form of warfare, even at the founding, and certainly today we haven't declared war since 1942. So often no text, and you might think, well, it's an old constitution. It is the oldest written constitution in the world. So that may be part of the issue. It's just written for a different time. But the other problem is, here are some of the examples. I've gone through most of them. So the other problem is, not only is it old, it's basically impossible to change. There's a provision for changing it. 2/3 of the House and the Senate, 3/4 of the states all have to agree. We've amended it a few times. Not on no foreign affairs issues powers have ever been amended in 230 years. We've just never amended the foreign affairs parts of the Constitution. Not to fill in the gaps, not to change them, not to update from 1789 foreign affairs to the 21st century foreign affairs, no amendments. And today it's basically impossible to amend. Think about how hard it is to get anything through any parts of Congress, let alone 2/3 of both chambers and 3/4 of the states. It's just not happening. So what do you do with a Constitution that's written for an entirely different time and the oldest written Constitution in the world that you basically can't change formally? This is just a dilemma for American constitutional law writ large, but particularly for the foreign affairs parts where everything's changed except for the text. So this is obvious. just some things that one might point out. The size of the country, we're not 13 former colonies on the eastern seaboard. We've got a continent, Hawaii and Alaska as well. We had about 5 or 6 treaties at the founding. We now have something like 15,000. How many people in the military at the start of the founding? Roughly 600 people in the entire armed forces of the United States, 600. We have a few more than that today. Economic power has grown exponentially, of course, particularly in the 20th and 21st century. The State Department, whatever happens under the current administration, is still going to be a lot larger. This is the executive branch, by the way, in 1789. The entire executive branch is around that little table. We've got some figures, you know, Jefferson and others. It's a little different today, just running the executive branch, even if there's some efforts to trim that down at the moment. So massive changes to the country, also to the world. I have this slide, my students like, you know, this is the constitutional period we wrote the text, and this is the one we're in. What do we do about that? And the answer that we have in a lot of areas of constitutional law, and if you studied constitutional law, you may kind of remember this, not a foreign affairs answer, is the courts. What we do have is judiciary that's kind of updated the Constitution controversially at times. It has sometimes not controversially, but it has been there, particularly in the rights area. If you think about the way rights were thought of in 1789 versus how we think about privacy and other rights today, there's been massive changes driven by the courts, but not in foreign affairs. The reason is a bunch of things that I'm not going to go through all of them, but there's just often no standing to sue in various foreign affairs disputes, unlike if somebody's individual rights are at stake where they can get to court. So a lot of cases in foreign affairs just never go to court. There's something called the political question doctrine, which doesn't have a ton of life at the moment in most areas, except for one, foreign affairs. If you looked at a bunch of lower court cases I have recently, that doctrine is heavily applied, particularly for any big foreign affairs issue overseas. When the military does things, predator drone strikes, you name it, political question doctrine, very common to shut down judicial review. And the judges, you know, this is not an accident, judges just don't think they have the expertise, the information they would need to make a good decision about trying to draw lines in the foreign affairs area. And the international law backdrop just turns out to be another complication because it's kind of evolving and contested, and the courts tend to want to leave it to the executive, to some extent to Congress, to kind of fight the international law battles and not have the US courts take the lead. And that just leads to a lot of abstention and lack of judicial decisions. When I teach a course on foreign affairs law, half of it's not judicial decisions. It's other materials, because I don't have Supreme Court cases that you would have in other areas. We just have never had the rise of judicial supremacy that we saw in other areas of American law in the foreign affairs, national security realms. So what happens? Well, this is the theme of the book, which is we still have law. We still have guidance. We still have settled law sometimes not settled. It's just not settled in the courts. That as we develop our constitutional law through non-judicial precedents that are then deemed relatively binding, that influence the next generation, over time they become a settled understanding of the Constitution. And the term in the book is historical gloss. I'll tell you in a bit why that is the term. That's part of the title of the book. That's the idea. These historical practices and views of Congress, presidents, others in the executive, over time, in dealing with the foreign affairs parts of the Constitution and filling those in, become kind of like a set of Supreme Court cases that are then part of our law. And one analogy, just an analogy, but why the word gloss? This is like a medieval manuscript. You can imagine the Code of Justinian actually is one of these like this, or a religious one, where these were people called the glossiers. Their entire job was just to gloss the margins of the text, to try to give meaning to the text. And one analogy is that the Congress and the executive, over long periods of time, are those people on the margin, are glossing our Constitution in the foreign affairs area. They're the scribes. This applies not just in foreign affairs, I should emphasize. That just happens to be my expertise. I would say separation of powers in general is heavily informed by the practices of government. And we all know it a little bit, even if we haven't used the term. So if you've ever remember this McCulloch case about the National Bank way back in the early days, Chief Justice Marshall. Already, think about how they only have 30 years of practice now. The Constitution only around 30 years. And he already is feeling like they have a lot of practice because a doubtful question about the powers of the government, this is about whether Congress could make a national bank, if not put to rest by the practices of government, ought to receive a considerable impression from that practice. That's precedent. But he's not citing any decisions there weren't any before McCulloch. Fast forward to Taft, who had a lot of experience as president, as also on the Supreme Court, says it directly. Precedents from previous administrations and Congresses create a historical construction of the extent and limits of their powers. No Supreme Court cases, but they've created the precedents over time. Probably the justice on the court who recognized this the most, if you had to pick one, is Frankfurter. The Youngstown steel seizure case, a war powers case, by the way, I'll come back to that, but everybody knows about the steel seizure case. Truman tried to seize the steel mills during the Korean War. He got knocked down by the court, and Frankfurter is famous for writing about how deeply embedded traditional ways of government can give meaning to the words. Think about the glossieres, and that's exactly the idea. Now, a lot of the examples in the book, and when I get to war powers in a few minutes, you'll maybe thinking about this as well, tend to benefit the president. And the reason is presidents have an easier time, you're seeing it right now, easier time acting and then seeing what happens in reactions. Congress is not so easy about acting. It has to, if it wants to pass a statute, it actually has to get enough votes, get through committees, and do all the collective action problems that a Congress faces. Presidents have one party at the top, one person at the top, have an easier time just kind of acting. And if they're not opposed, we will see over time a set of practices that might enhance executive authority. And the story many people tell of the 20th century going into the 21st in foreign affairs is the rise of the powerful presidency in foreign affairs. And some of that's evident in the news right at this moment. Presidents do have a lot of accrued power. If you don't like presidential power, you're going to worry about the dynamic that I'm describing, and probably really in the war powers area, which I'm getting to. But I always remind people, and there's a whole chapter in the book about it, Congress gets a lot out of this too. There's a bunch in the Constitution where we're not sure if Congress can actually regulate the president. It's not clear. Or certain topical areas. We know that President Washington in the early days, 1793, declared neutrality. Can Congress get into the picture? Well, they did a year later. And it just got accepted that they could regulate neutrality and the consequences of violating neutrality. And presidents accepted that, and nobody really questions it. But it didn't start out that way. I won't give all the examples. They regulate passports since we ever started doing it in the 1850s. Nobody doubts Congress can regulate passports. But where's that? It's not in the text. Immigration, one of their biggest powers outside of money, everybody accepts that they can write the immigration code, because they do, and they have since we started having general immigration laws in the late 1800s. But it's not in the constitutional text. They get a lot out of it. And in the war powers area, I won't give you most of the examples, but one that's very important is they have, of course, they regulate the armed forces, but that is in the text, in the UCMJ. But they also regulate other things like the treatment of prisoners of war in the modern era. You could imagine a president saying, no, that's my commander-in-chief function. But it's well settled, and the Supreme Court itself has said practice has pretty much settled that question. So Congress is not completely losing out, even if presidents benefit from historical practices. The other way in which they benefit, Congress benefits, is it became accepted in a bunch of areas that presidents cannot act alone, particularly in areas that affect certain kinds of liberty interests. And that just became, not because of the text of the Constitution, and there's no text. Can a president just grab somebody and extradite them? No. The Supreme Court has said it multiple times. Why? Because the historical practice of the 19th century, fortunately starting with Jefferson, who said, I don't know the answer, but I think because of liberty, the president should have to have a treaty or a statute behind them. Thankfully, he said that because it became kind of the norm, but it could have gone a different direction, but Congress benefits from it. So we have an extradition statute. We have treaties on the subject that enhance what the executive can do. A lot of immigration stuff I've already mentioned. Criminal laws abroad, there are a lot actually, but those are all coming from Congress. Trade, of course, even though presidents have a lot of power, it's because Congress delegated in the trade statutes. And money, a huge fight's going on about money right now, but the conventional wisdom is Congress holds the purse. And all of that's settled by practice. So Congress is not completely left out here. The most important separation of powers point in the book, though, is this one on the slide. And it is always relevant. It's really relevant now. And so I'll emphasize it more than once, which is even if presidents get a lot of power over time because they've done a lot of things, Congress hasn't really fought back, which is true, they don't get exclusive authority out of that picture. That dynamic does not freeze the legislative branch out. I go into a lot about that in the book. It just shows that when Congress is on the sidelines, presidents often have the power of initiative. That is how American foreign affairs largely works. That's been true for a long time. But it doesn't mean Congress can't come into the picture. And there's a famous quote from Justice Robert Jackson. By the way, he knew what he was talking about. He had already just served at Nuremberg as the chief prosecutor against the Nazis. He knows what fascism and authoritarianism looks like, and he's speaking to that in the seizure case just a few years later when Truman has seized the steel mills in the United States. And he's resisting the idea that we should have much in the way of preclusive presidential power that freezes Congress out. And he says this would really mess up the whole equilibrium of our system. And then he ends with this cautionary note, which we can always use. We know with all of its defects, delays, and inconveniences, men, of course, but humans have discovered no technique for long preserving the free government except the executive be under the law. And everything about historical practice is consistent with that story. If you don't agree with that story, you have to have some other theory. If presidents don't want to be under the statutes, it's not going to be because of practice. It's going to be because of some other claim. And I'll remind you of that when I get to the war power stuff in a minute. It matters, I said. It always matters. But I like current examples when I can use them. This is a law in the U.S. Code passed a year ago, a little over a year ago, and it says the president cannot pull the United States out of NATO. Full stop, unless the president gets either a majority approval from Congress or 2/3 of the Senate. NATO was ratified, by the way, in the late 40s by 2/3 of the Senate, but Congress is saying either the majority or the 2/3 is good enough, but not on your own. That's a law. Biden signed it into law. No signing statement. It's in the code. Now, the Justice Department's sort of think tank, Office of Legal Counsel, did claim in Trump's first term about a different treaty that, and really for the first time, that presidents have this preclusive, the stuff that Jackson said we really ought to be watching out for, and such that Congress can never regulate a topic like this one. That's OLC in 2020. Historical practice is all against OLC. Why? I have a whole chapter. I won't go through it now. The entire 19th century, Congress was involved in every treaty withdrawal the United States ever had. And presidents thought they had to go there, or they went to the Senate. Exactly what the statute says. So no record of a preclusive presidential power for more than 100 years, and actually after that. All we have after that is presidents tend to act when Congress is silent. And Congress usually doesn't fight about it. There have been a few times they have. A few times, by the way, Congress, even in the modern era, when they didn't like what South Africa was doing, Congress just mandated Reagan pull out of some treaties, and Reagan did. So the idea that practice supports OLC, not there. You'd have to have some other theory, like all the practice is wrong, and there's some sort of nature of executive power means that Congress can't regulate in the way that it has done before, but that's pushing against historical gloss, not working with it. And again, Jackson's argument, I would say mine in the book, is the presumption heavily goes to shared power and not to closing the lawmaker out of the picture. And I think checks and balances really have a hard time once you say Congress can't get into the picture. You have to have very good arguments for it, and I don't see them for that. We'll talk about it for war as well. Okay, so that's the gist of the book in general. National Security Conference, I wanted to talk about war. By the way, this is the most controversial chapter by far in the book. Every other place I've given in this talk, I have purposely not talked about this chapter. Okay? Just because you can only do so much in 30 minutes or something, and believe me, people get very unhappy about the war powers issues. They don't like how things have gone. They get worried about it. So I have much milder examples in the book where almost nobody argues with me. That's a more pleasant experience for me. But I'm gonna be brave and talk about the hardest topic in the book, which is war. Now, there's stuff in the text. Congress has the power to declare war. That's a good start. And lots of regulatory powers about the armed forces, marks and reprisal, lots of things. But the president's made the commander-in-chief, so how do we accommodate these different pieces of text? Lots of unclear issues came up right after the Constitution. What if it's not a declared war against the French in the late 1700s? We never declared war against the French in the naval war. Well, how does that work? Because there's nothing in the text exactly about that. Because it says Congress can declare war, but what if they don't? What about just defense? Congress was not in session more than half of every year in the early days of the nation. You're telling me the president has to say, please, Congress, reassemble wherever the nation's capital happened to be at that point, and in a few weeks, maybe would you vote on a resolution after we've been conquered? No, I don't think so. You have to have some defensive power as a commander-in-chief. And everybody agreed pretty much with that, didn't write it into the text, unfortunately, other than just the words commander-in-chief, unless you want to imply that. Well, Congress can declare war, but what is a war? What if you're attacking a band of pirates off the coast of Florida? That happens. What if it's not a recognized state? It's some community of rebels in Nicaragua or something. Is that a war? Well, what is a war? Not entirely clear. And the Indian tribes raise their own issues, of course, as well. And I can tell you, making a long story short, that lots of presidents in the early days, and Congress, had to just kind of feel their way through those issues and figure out what's going on. One of my favorite figures in the 19th century parts of the book, and I think maybe the best American statesman in history, is John Quincy. He's certainly the most educated, read in Latin and Greek and everything else, maybe not the most fun guy in the world, okay? But he also spans a period of time, it's just amazing. He was a teenager sent by his father, of course, John Adams, to go help negotiations with Russia while he's a teenager. He observes, when he was about 10, the Revolutionary War going on in Massachusetts. And you can see a photograph of him as well. Quite old at that point, but he spans a lot of the early American history, and he serves in all capacities, by the way. He serves as Secretary of State, he serves as President, goes back to Congress and fights against slavery. Major career in all parts of the American government. And what does he say? Because he's a pretty thoughtful guy about war powers. Well, to show you the not fun part of him, he's giving a eulogy in 1836 for James Madison. You might think a eulogy would be just highlighting important parts of a person's life. No, he writes a book as the eulogy. Part of it's just about war powers, interestingly enough. And this is his observation. He feels old, but he feels the country's old. Now, it doesn't feel that way to us. 50 years out, we've got 230. But he already feels like the country's been through so much and survived. And this is his observation, however startled we might be, if you look at the text, that the president has the power to get us into war, even without going to Congress. This long experience of 50 years proves that it must be that he does. Why? Because of all of these hard cases. Naval battles around the world. We now have a Navy, finally, that's going around. They get in pitched battles of various sorts. They don't go back to Congress. In fact, they often don't go back to the president. They have to just go on general orders. Lots of things that are happening the founders don't write in. And Adams is already noting, it can't just be that you look at the text and you think you solve this, because we already know from 50 years it's much more complicated. And that is a theme in general, I think, of the book. What do you do about defense? It came up an early war, a couple of presidents had to deal with these. These are state-sponsored terrorists, basically, the Barbary pirates. These are not just pirates of an ordinary sense. What do you do other than pay tribute, which is what the European powers were doing? Well, our presidents decided we're going to fight back, and they did. But do you need Congress for that? Is it a war? The Barbary states sometimes thought they were in a war, but does that make us in a war? Well, Jefferson, famously, kind of timid, at least overtly, we had some naval battles. He said all he could do is have his naval commanders fight back, stop the firing of the Barbary pirate ship, and then it had to stop. It couldn't take the vessel, and it could not follow the vessel, assuming it could still move, into port, even though the next vessel may come out to attack again. Alexander Hamilton said, why are you being such a timid person, President Jefferson? Once they attack us, surely we're in some kind of war that allows the chief executive to do more than just stop the immediate source. Maybe they can take the fight back and stop the whole threat. Well, both sides are kind of reasonable in light of the text, and some presidents are much more aggressive than Jefferson, and it just varies over time. Well, make a whole 19th century kind of, obviously a lot's going on in the 19th century. Everybody agrees some defensive war authority, just lots of variations about what that might look like. Lots of low-level uses of force, particularly in not sort of major European conflicts, other kinds of conflicts in other countries. But not real big ground force situations without Congress. And probably more authority to go without Congress if it's non-state actors, not recognized states. The big wars, ground wars and the like, or a big naval war against the French, most of them were declared by Congress, not the naval war, but everything else, War of 1812, Mexican-American War, Spanish-American War at the end. and certainly authorized by the legislative branch. So the big kind of protracted campaigns, but lots of low-level uses of force, never going to Congress. And we're not talking today, we're talking a long time ago. Big change. I don't know if everybody knows this from history. So most of these smaller engagements are, we have a couple of naval vessels that shoot, maybe take over a village or something like that. It's not a huge amount of forces. In 1901, the United States now has big forces overseas. Why all of a sudden? Spanish-American War, which it has just won. It has the Philippines. It has a bunch of troops there. There's the Boxer Rebellion in China, and some Americans are threatened. So McKinley is just able to send well over 5,000 American troops, part of a multinational force, into China. And they go all the way to Beijing and other places. No congressional authorization, pretty big land forces for the time, and I think they were celebrated because they stopped the Boxer Rebellion and Congress didn't get too uptight about the constitutional issues. But think about what's changing. Now you have bases overseas and troops stationed already. You don't have to take as long to get to the Mediterranean or any other place. And of course, technology is playing a role in that. Presidential power's going to be affected by that, just as a practical matter. So that takes us into the 20th century, and I won't go through all the details. Some of you probably know it, but early 20th century, controversially, Teddy Roosevelt, Taft, and others are using American forces in Latin America, among other places, to do a lot of things. Keep European powers out, protect creditors, protect against sort of mob situations, lots of so-called police actions without Congress, mostly not generating big constitutional fights, by the way. Of course, the world wars are authorized and declared by Congress, but the last time we've ever had a declaration of war was in World War II, in Romania, I think, and that is a long time ago, and Congress' power to declare war, if that's all it means, it hasn't been exercised in almost a century. Korean War then comes along. This is now we're done through World War II. We've got the UN system set up. What happens? Well, Truman is the president. He does the Korean War, which has massive amounts of troops, massive amounts of casualties too. It becomes very unpopular without Congress, without an express authorization from Congress. We can talk about what Congress did do, but he purposely doesn't go to Congress. His Secretary of State Atchison says, it'd be a good precedent for a big conflict not to go to Congress, and he doesn't. Now, it's super popular that for the first month or so in Korea, got to stop the communist threat coming from the north. He would have gotten Congress on board with only a few negative votes, I think. Taft would have been one of the negatives, but not many. But he doesn't do it, and he wages this big Korean War without congressional authorization. What do we do with that if you're looking at practice? And lots of casualties. It becomes very unpopular, and many people in Congress say, you should have come to us at that point. Now it takes me up to the sort of the modern era. Where are we at today, literally right at the moment? Well, after Korea, I would say we don't have anything like Korea since the Korean War. That is a big, protracted, high-casualty ground campaign without legislative authorization. There's nothing quite like that, and if you think Congress is better for Congress to be involved, that's good news. And the most protracted conflicts in general since Korea have been authorized by Congress to one degree or another. The Vietnam War was super unpopular, including the draft and other aspects of it, and the fact that it went on so long. But there was the Gulf of Tonkin Resolution, talk about that, but at least it was a statute, eventually repealed in the early 70s, but it was a statute. And the Iraq wars were both authorized by Congress. Some of the members of Congress would like to forget they voted for those, but they did, even the second one. And the War on Terror, War in Afghanistan, we still have that statute, the AUMF from 2001. Obviously, Congress voted that a few days after 9/11, in fact, and it's still on the books. And actually, the second Iraq one is on the books, too, and that causes some issues. However, if you just counted the numbers of uses of force, military bombings, even some invasions, many more have not been authorized by Congress, including short-term invasions of Panama, Grenada, bombing campaigns in Kosovo and Libya, many other aerial uses of force of various kinds, no specific authorizations from the legislative branch. So what do we make of that? Well, one other item, and this goes back to Jackson, I said I'd come back to him, is that Congress has often been kind of quiet on the sidelines, to be honest. And I think there are some institutional reasons, unfortunately, for that, but not at the end of the Vietnam War. And Nixon was, of course, about to be impeached anyway. He was very unpopular. He vetoes this, but he loses. This is a statute. Don't be fooled by the word resolution. It's a statute. It's in the code. Passed over his veto. So 2/3 of both houses of Congress passed this. And it says, the most important part of it says, that within 60 days, President, if you've started using forces in hostilities or imminent hostilities, you have to stop unless you get authorization from Congress. That's still the law of the United States. Unless it's unconstitutional, that's our law. And we can talk, if you want, about whether it's constitutional. But again, the presumption of the Jackson regime is the burden of proof is heavily on those saying presidents don't have to comply with statutes. Now, it is actually interesting now some presidents have suggested they think this is unconstitutional, and some have kind of grudgingly gone along with it. It's really varied. I would say it's hard to find any president who has used force and said, I'm just not going to comply with the statute. That is not happening. What you do find is that Panama and Grenada are done in less than 60 days. Well, that's interesting. Or you find that it's a short-term bombing campaign, not going to run into 60 days. Or there's some workaround arguments, like there have been some executives that said, well, you gave us in Kosovo supplemental appropriations, which we asked for, that took us beyond the 60 days. You didn't have to give us that money, and if you did, you're kind of authorizing the additional bombing in Kosovo. And, I don't know if I agree with that argument, but it's an argument to try to work with this. The least persuasive argument, but I got to mention it. It's from one of your speakers from earlier today. I won't mention who, but this person made the argument in government, which is if we're bombing the heck out of Libya, we're not in hostilities because they're not bombing us back. So therefore, we don't have to worry about the War Powers Resolution. We can keep bombing. This persuaded basically nobody, okay? That person had to testify in Congress. Nobody in Congress was buying it. But they didn't do very much about it. That bombing campaign in Libya did last longer than 60 days. And if that's the only argument, because obviously, just because they may not directly be able to fight back, anytime you're in a campaign, it has risks for the United States. Regionally, generating terrorism and other things, that would be the argument for having to go to Congress for anything like that. And that was probably not the best workaround argument. But that's a statute, and I would say it's had some effect, although a lot of people think it's poorly drafted, which it might be. Here's, if you ask the executive lawyers today, and I don't think it's different to right this minute under Trump, because this is a pretty recent viewpoint, is, first of all, they would rely heavily on practice. They do it across foreign affairs, not surprising. First of all, what else are you going to look at? No Supreme Court cases. So if you don't have judicial precedent, you got to look at some of this stuff. It's part of the theme of the book. And look, they say it's 230 years, literally, from the halls of Montezuma to the shores of Tripoli, that's the Barbary pirates and beyond. We've had not just Congress always in the picture. And you can't say, the executive would argue, that we have 230 years of unconstitutionality. That's just a hard thing to argue. So it can't be that we always have to go. And the kind of consensus position, by the way, this is Democrats and Republican lawyers kind of having a consensus on this, surprisingly, which is you look at the anticipated nature, scope, and duration of the conflict. This is just not long ago. And what do they mean by that? I think they mean aerial campaigns, kind of like the Libya thing or anything else, that's not likely to generate a big troop presence on the ground, may not have to go to Congress. If another 2003 Iraq war looks like it's on the horizon, there's sort of a concession. You do have to go to Congress for that. It's something along those lines, but obviously lots of vague discretionary stuff about when it would rise to the level of a war. But interestingly, they're conceding they can't always do it on their own, which is more than sometimes presidents, I think, have conceded. Well, nobody's perfectly satisfied with what I'm describing. This is why it's the hardest chapter in the book. People worry about presidents making very unwise choices with the use of military force, and those can have massive consequences down the road or directly for the United States, blood and treasure and other costs. We want to make decisions wisely about that. And also our relationships with other countries in the world are hugely affected. And if you don't trust presidents to do a very good job on their own, you would love the legislature to be involved. Now, they're not very good about it. This is a dilemma when I teach this. My students would love, most of them would love to see Congress just assert itself. The problem is Congress's desire is not to assert itself. Its desire is to wait and see how the conflict goes. And if it's going well, they were always in behind it. Didn't you know? They were always saying nice things about it. If it doesn't go well, we never approve this. That's a presidential mismanagement problem. And they should have come to us. And they kind of have it both ways, but it means they don't. I'll give you an example of one of many. This 2001 AUMF A paragraph is the entire statute, written 3 days after 9/11. Okay, we needed something on the books. Glad we got something. It is not a good statute for 2025 and the so-called war on terror. It has no knowledge in 2001 of anything like the world that we have today and what we need in terms of authorization. It has never been amended, repealed, nothing. And one President Obama actually said when he knew he was going to have a big conflict against the Islamic State, not really Al-Qaeda, he said, you know what, we ought to probably have a new statute. Here's a proposal that would actually limit my power with respect to it says, for example, I can't introduce major ground troops without going back to you. That's a big concession for a president. He gives them a proposal, they sit on it, nobody votes, we get no new statute. We still have the one paragraph from 2001. The entire war on terror fought based on a one paragraph that it was based on Osama bin Laden and things that don't really apply anymore. So Congress is part of the problem, and I don't have an easy fix for that. But if they wanted to be more assertive, money is a way. They can defund anything. They did at the end of the Vietnam War. They did in Somalia. They have some power because presidents can't fight wars without money for very long. I think the War Powers Resolution is probably a binding statute. Congress probably ought to speak up. Probably ought to revise it. They're like define hostilities. So if you're bombing a country, it actually is clearly in the statute. But the president might veto it. So the question is, will they do it, or can they do it? And I would say updating some of these statutes that the presidents nowadays, by the way, don't even have to go back to the practice that much. They can say this vague statute from 2001 lets me do just about everything. Congress has some responsibility, obviously, to do something about that. Every time I think we're going to do it, the politics change, and then we don't. But I would say this is where I would look. I'm happy to talk about any of those things, by the way. This is the bottom line, my last slide, the sort of theme of the book. Whether you agree on war powers or any other examples, the point is really about how we understand the American constitutional law, given that it's so old, impossible to amend, never amended the foreign affairs provisions, that it's an inadmissibly narrow conception of American constitutional law to confine it to the words of the Constitution and to disregard the gloss which life has written upon it. And that's Frankfurter from the Steel Seizure case. So thank you. Yeah, sure. Yeah.
Unfortunately, we are out of time, but here's the good news. Professor Bradley is going to the reception. I know a lot of people will have a lot of questions for him. I'm a Bradleyan in my constitutional analysis, I can tell you, and I want to put that on the record. And we're going to look forward to seeing him. A couple things real quickly. Have to bring up some other slides.